Good morning, everyone. Thank you for being here. Let me join in welcoming you on behalf of the CEU Democracy Institute to this European Media and Academic Seminar, Fundamental Rights, Climate and the Environment, from the Courtroom to the Newsroom. The DI is proud to co-sponsor this event that is going to explore how journalists can cover strategic litigation and watchdog efforts around climate and environmental governance. The occasion of this seminar and the reason why we are having a special focus on constitutionalism and fundamental rights is thanks to the landmark case of the Hungarian Constitutional Court from June of this year, in which the court struck down a part of Hungary's Climate Protection Act. There are certain similarities in this case to the now famous Dutch Oorhende case from several years ago, in which it was determined that the government of the Netherlands had an affirmative obligation to meet its legal and policy commitments in the field of climate change and was required to develop an effective plan to do so. That case was based on a special legal concept under Dutch law of a public administrative tort or wrong, whereas the Hungarian case goes much further in characterizing the obligation of the public authorities not only in terms of international agreements and policy commitments, but also as a matter of fundamental rights and constitutionalism. You will hear more about the case, so I don't want to give you any spoilers now. You'll also discuss the Charter of Fundamental Rights, the European Convention on Human Rights, and the intersection of basic rights with environmental protection. You'll be discussing the jurisprudence of the European Court of Human Rights under Article 8 of the Convention, which is quite interesting in that it approaches a right to a healthy environment without the support of any direct text in the Convention. I also want to thank my colleague at CEU, Professor Medavoy, who will share his research on climate change anxieties as an animating force for racial politics of threat. I'm very sorry I will be missing these and other presentations today, as many of them fit in with the work we are doing in our work group on environment and democracy at DI. The variety of cases, the range of legal theories that have been used to bring environmental issues before the courts is not only remarkable in its sheer volume and diversity, it is a symptom of something deeper. It is a symptom of the struggle to fit extreme complexity into traditional legal forms. It is evidence that the human mind is exercised constantly in trying to find new ways to beat against business as usual, which is leading us to the edge of crisis, to shift our way of living towards sustainability, even through the courts. And that is a story in itself. I'd like to tell you a little bit about some of my experiences. On one end of the spectrum, I've attended several meetings of the EU Justices for Environment group, and in one of them there was a side meeting about an upcoming UK case hosted by Lord Carnwath of the UK that included all the top barristers on environmental and climate cases from that country. And I believe I was invited perhaps because I came from a kind of a common law country. In any case, I won't forget something that Lord Carnwath said. The discussion was around whether it was appropriate or proper for the judiciary to take up the case, which was about fundamentally political matters, such as how to reach certain societal goals in the field of climate. In the United States, I'm sure that the judiciary would have said this is a political question and would have stayed out of it in favor of the legislative and executive branches. But Lord Carnwath essentially said, under the constitutional system, that when the government and parliament have been ineffectual for so long in carrying out their responsibilities to solve pressing societal problems, then it is in fact the duty of the judiciary to step into that role with the tools it has at its disposal to force action of the other branches. At the UN level, the expression of the urgency of the situation comes in the term all of society response. and all of society response requires other institutions and individuals to fill in the gaps when others fail or fall short. That, of course, will not be a strange concept to the journalistic community, which has been called the Fourth Estate. On the other end of the spectrum, let me tell you a personal story from my work in Ukraine 30 years ago. So in preparing my introductory remarks for this seminar, I was transported back those 30 years to a time when I was working in Ukraine with a diverse group of dedicated and enthusiastic lawyers, most of them just out of law school, in what was called the Environmental Public Advocacy Center, or EPAC. And there was no shortage of cases in the 1990s in the post-Soviet space. CEU has a distinguished academic, Rubin Menatskanian, who thoroughly researched the environmental legacy of the Soviet Union, and it was not a pretty picture. In attempting to hold the public authorities and enterprises to account, our first important partner inside the center was a staff scientist who could provide us with the data and the scientific expertise that we needed to prove our cases. The next stage of our strategy, after bringing on the staff scientist, was to reach out to the journalistic community, who then, as always, were valuable partners in fostering dialogue, understanding, and truth, while also keeping us on our toes. I remember one day in the EPAC when a low-level public official, nervous and out of breath, came running into our office and asked for my young colleague, who is now a distinguished member of the Aarhus Convention Compliance Committee. He handed my colleague a stack of yellow papers, got a signature, and ran out. It was so startling that I asked him what had just happened. This stack of 14 pages of handwritten information was the first recorded response to a public information request under the new Ukrainian law, not only in the field of environment, but in any field, because environmental concern was then the main driver of civic action in Ukraine. It was because the local press was paying attention every day to what we were doing and would have reported on it immediately if the regional authority had not complied with its obligations. Otherwise, we were toiling away in the darkness, and it would not have been surprising if no one had taken notice. That was at a time when access to information, public participation, and access to justice were still relatively new and evolving tools and mechanisms. We were lucky that we had at our backs the winds of change due to the legacy of industrial pollution, and we were then part of a widely supported social movement. Now, after many years of success, the winds have changed once again, and progress in addressing climate change, legacy pollution, and threats to biodiversity has stalled, as we see most recently in the conclusions of COP30 and even the Aarhus Convention meeting of parties. Meanwhile, as we make progress on one environmental issue, new ones raise their heads, for example, related to nanoplastics, PFAS, solar radiation modification, and artificial intelligence. This makes it all the more important to reach the people with true stories about what is at stake. It says in the overview on the agenda to our meeting that journalists are aiming at translating important legal developments into accessible narratives. Concepts such as intergenerational justice, the precautionary principle, and the right to a healthy environment are not always easy to write about as a journalist, and so I wish you luck. It's a very rich and packed agenda for today, covering what makes court cases powerful levels for accountability, and hopefully you will have a fruitful exchange about how to tell those stories in ways that make a difference. I wish you a successful and productive seminar, and hope to welcome you back for future events and activities at the Democracy Institute. Thank you.